Good morning. It is 8:27 a.m. on the 9th of July. This is the first regularly scheduled OCD docket. It is hearing by affidavits, and these are uncontested cases for those in the public who don't know what hearing by affidavits are. I'm going to start with case 25746. This is Mewbourne Oil. Entries, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Mewbourne Oil Company.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2.
Thank you.
Good morning, Mr. Examiner. Adam Rankin with the Santa Fe Office of Holland & Hart, appearing on behalf of Marathon Oil Permian.
And I suspect that you don't have an objection to this case going
No
forward.
objection going forward. Just appearing to preserve rights.
Avant had objected to the case moving forward, but we withdrew the objection, and so monitoring.
Perfect. Thank you.
you.
Ms. Hardy?
Thank you. In this case, Mewbourne seeks to pool uncommitted interests in the Wolf Camp underlying a 640-acre standard horizontal unit comprised of the east half of sections 26 and 35, Township 23 South, Range 26 East in Eddy County, and proposes to dedicate the unit to the Rooster 3526 State Comwells. Our exhibits include the land testimony and exhibits of Brad Dunn, who has previously testified before the division. And we've also provided the geology testimony and exhibits of Tyler Hill, who has also previously testified before the division as an expert in geology matters. Our notice information and testimony shows that we timely sent notice to all interested parties on December 30th of 2025 and timely published on January 17th of 2026. So with that, I ask that the exhibits be admitted and that the case be taken under advisement.
Exhibits are admitted without exception. Mr. Fordyce?
Yes, Mr. Hearing Examiner, I'm here. Apologies, my camera's on the fritz today, but I do have questions for the landman in this case.
Go right ahead, Ms. Hardy.
Mr. Dunn should be on the line. There he is.
I see. And Mr. Dunn, please raise your right hand. Swear or affirm that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
All right, thank you. If you can lower your hand and please spell your name.
It's Brad Dunn, BradDunn.
And you've been previously qualified as an expert before this division?
Yes, sir.
In what field?
Land management.
Thank you. Mr. Fordyce?
Mr. Dunn, I'm looking at your landman statement on page 6.
Yes, sir.
And
Hold up.
I'm looking at paragraph 10.
Okay.
Which says Mewbourne will seek administrative approval of the non-standard spacing unit. Do you still believe that Mewbourne will need to seek an NSP administratively?
No, I don't believe so, because these Wolf Camp wells cover the spacing that we need, so I don't think that's needed any longer. Good question.
Okay. If we could scroll down to paragraph 14. It says that Mewbourne's requesting overhead rates of 8,800. In the compulsory pooling application checklist on page 3, it has 10,100. And on the well proposal letter on page 22, it has 12,200. I was wondering if you could help us narrow that down to 1.
Yeah, 12,100. The last one that you read is the accurate figure. So I think these were I missed that in this originally. I think these were sent out a while ago, and the higher number is the correct figure. That's been our standard.
So it should be 12,100. Is that what you said?
Yes, sir.
Okay. I have no further corrections or questions. So we need to get corrections on those things we just covered in the landman statement, and the CPAC would then need to be corrected to reflect the correct overhead rates.
We can submit that today.
Okay. Did you include a cover letter?
Yes, we will.
Explain, and I think you're taking out a paragraph of
Yes.
Mr. Dunn's.
We will do that, yes.
All right, sounds good. All right, we'll leave the record open until 5 p.m. today.
Thank you.
We're off the record in that case. Let's move on to 26133, Burke Royalty.
Good morning, Mr. Hearing Examiner Yaritza Pena on behalf of High Plains Natural Resources and Burke Royalty Co.
Morning.
Good morning. I don't believe that there are any other parties in this
Go right
case.
ahead.
In this case, High Plains seeks an order pooling all uncommitted interest in the San Andres Formation, underlying a 320-acre standard overlapping horizontal spacing unit in the west half, east half of irregular sections 11 and 14, Township 13 South, Range 38 East in Lee County, New Mexico. And this unit will be dedicated to the Gale Fring Federal Com 3H well. High Plains seeks approval of the overlapping spacing unit and further seeks to designate Burke Royalty as the operator of the unit and the well. Exhibits were timely submitted last week and include land testimony and exhibits of Josh Morian, who has previously testified before the division and has been recognized as an expert in petroleum land matters. And the packet also includes the geology testimony and exhibits of Ben Ryan, who has not previously testified before the division. And if there are any questions for him, we would seek to have him admitted as an expert in geology matters. His resume is attached as Exhibit B1. Finally, in our notice testimony, we include copies of the notice letter, which was timely sent to all parties on April 30th, 2026, and the affidavit of publication from May 10th, 2026. I ask that the exhibits be admitted for case 26133 and that the case be taken under advisement.
The exhibits are admitted without exception. Mr. Fordyce, who do you have questions for?
I have questions for the geologist.
Okay. Would you call your geologist?
Yes, Ben Ryan.
Good morning. Y'all hear me?
We can hear you, Mr. Ryan. We're just looking for you to put you up on the screen for us.
Okay.
Is your camera on by chance?
Yes.
Yes, perfect.
Ms. Pena, would you share his resume on the screen?
Yes, absolutely.
This may be an easier way of doing this. Mr. Ryan, while she's sharing her screen, would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Would you spell your name, please?
BENRYAN.
Okay, thank you. And you're seeking to be recognized as an expert, as a geologist before this division?
Yes, sir.
Have you been recognized as in the field of geology in front of any other forums?
Yes, sir. I've gone before the Railroad Commission in Texas for multiple unit hearings.
Okay. As an expert in geology?
Yes.
All right, thank you.
So would you like me to talk through, I guess, my resume right now? Sorry.
No, I'm just reading it.
Oh, okay.
Ms. Pena, would you raise it a little bit?
Yes.
Thank you. It's perfect. All right, thank you, Mr. Ryan. This division recognized you as an expert in petroleum geology. Mr. Fordyce?
Mr. Ryan, if I could direct your attention to Exhibit B2, which can be found on page 31. I'm looking specifically at the gun barrel depiction, and it took me just a minute to figure out what I was looking at here, but I was thrown off a little bit because I believe if you will look at the description for the location of the bottom part of the gun barrel, I think that legal description needs to be corrected to reflect Township 13 South, Range 38 East, and Section 14, rather than Township 14, Section 11. Would
Yes,
you
sir,
agree
that
with
is
that?
correct. Yes, sir.
Okay.
Noticed that this morning.
If we could scroll down to the next exhibit on page 32, looking at your cross section, I was wondering if you could provide, if it's possible, to provide a cross section that has a little bit more vertical extent, allowing for some applicable formation tops to be shown for the exhibit, to demonstrate to people who aren't geologists by trade, perhaps, where exactly we are here. If we could include formation tops, and also I was wondering if you could narrow down a proposed landing zone within this 300 feet. Be a little, if you could be a little more specific about where the target and landing zone were.
Yes, sir, we can do that.
Okay. Then I have no further questions for Mr. Ryan, and if he can submit amended exhibits, I would like to continue this case so I could review those.
Thank you, Mr. Fordyce. Ms. Pena?
Yes, so we can submit those exhibits. We could submit them by today at 5 o'clock with a cover letter, but it sounds like Mr. Fordyce wants to review them.
Yes. Mr. Fordyce, when is the next docket that you'll be a technical examiner on?
I'm not sure, Mr. Hearing Examiner. The next available, I could be available to appear at any of them, I believe.
It's hard to understand you. Would you repeat?
Don't know if I'm assigned to any particular ones that I could name at the moment, but I would be available to review them.
Okay. All right. Is there a, Freya, when is the next docket this case could be put on before the August HBA docket?
We have a special docket on July 28th.
Okay. July 28th?
That would be great. Yes.
Okay. All right.
Thank
you. A cover letter, amended exhibits, and you'll move the case to July 28th.
Yes, correct.
Thank you.
Thank you.
We're off the record in this case. Let's move on to two cases that we have a different hearing examiner for. These are Oxy USA 26143.
Good morning, Mr. Hearing Examiner Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of the applicant, Oxy USA.
Good morning.
Morning. I don't think there are any other parties in this case, Mr. Examiner. This is an application to amend compulsory pooling order R22683. This was previously presented to the division on the June 30th docket. At the time of the presentation of the hearing, the examiner requested that Oxy provide some supplemental and revised exhibits. We did so and submitted those in advance of this hearing. The exhibit packet was filed complete with Oxy revised Exhibit C, which is a revised landman statement, identifying updated pooling exhibits, a copy of the administrative application for approval of a non-standard spacing unit as requested, and those are attached as Exhibit C2 and C3. Unless there are additional questions based on the submissions that Oxy has made, we ask that the case be taken under advisement.
Your exhibits are admitted without exception. The case is taken under advisement. Let's move on to case 26144, Avant Operating.
Morning, Mr. Hearing Examiner. Caitlin Locke appearing for Avant this morning.
Thank you. Is Mr. Philip White available, or has he withdrawn from the case, Ms. Luck?
My understanding that he's withdrawn his appearance at this point in time. This case was originally heard on the June 30th docket, and it was continued to today so that I could make a correction to this CPAC as requested by Examiner McClure, as well as provide a waiver of notice from Coterra, and an amended exhibit packet was filed last week with those amended exhibits. So at this point in time, I would just ask that the exhibits be admitted and the case be taken under advisement.
Thank you, Ms. Luck. Did you provide a cover sheet to explain what you were amending?
I'm sorry, I'm not sure that I did provide a cover sheet, but I can file one.
Would you refile the amended exhibit packet with the proper cover letter explaining what changes you've made?
Yes, Mr. Hearing Examiner.
Okay, and we'll leave the record open until 5 p.m. for you to do that.
Okay, thank you.
We're off the record in this case. Let's move on to Permian Resources. This is 26157.
Good morning, Jackie McLean on behalf of Permian Resources,
Good morning.
and no other party had entered an appearance in this case.
Go right ahead.
Thank you. In this case, Permian Resources is seeking to pool all uncommitted interest in the second Bone Spring interval of the Bone Spring Formation underlying a 480-acre, more or less standard overlapping horizontal spacing unit comprised of the north half of Section 15 and the north half of Section 16, Township 20 South, Range 28 East in Eddy County. And this unit will be dedicated to the Foster's well. Exhibits were timely submitted for this case and include the land testimony and corresponding exhibits of Adam Recker, who has previously testified before the division, as well as geology testimony and exhibits from Chris Rudelhuber, who has also previously testified before the division. We also included our notice testimony and copies of the notice letter, and we sent out two on May 6th and June 18th. Both were timely, along with an affidavit of publication from May 13th, 2026. I ask that the exhibits be admitted for case number 26157 and that the case be taken under advisement.
The exhibits are admitted without exception. Let's see. Mr. Fordyce, we have the two witnesses up here on the screen. Who do you have questions for?
Mr. Hearing Examiner, I have questions for the geologist.
Is that Mr. Rudelhuber?
Correct.
All right.
And I can share my screen with his exhibits.
Please. Good morning. Would you raise your right hand? Do you swear or affirm on the penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Would you lower your hand and spell your name?
CHRISREUDELHUBER.
Thank you. You've been previously qualified as an expert before this division?
Yes.
In which field?
Petroleum geology.
All right, thank you. Mr. Fordyce?
Good morning, Mr. Rudelhuber. I'm looking at, if I could direct your attention to Exhibit B2 on page 30.
Yep.
The first request is on this exhibit, and the same for B3 and B5, if it could be corrected to show the spacing unit correctly, as it does not contain or include the south half of the north half of 16.
Understood. I can correct that.
The other question I have, this application involves a depth severance, and the log used to describe that is the Oxy Bulldog State number 1. And that well is located in unit letter H of section 16, which would have fit in nicely with this cross section. I'm wondering if there's a reason why it was not included, since it is the log that's used to describe the depth severance.
I can amend that if that's what you're requesting, to include that in the cross section.
Yes, I would like to see that log in the cross section, which is Exhibit B4. And one last thing, actually in the CPAC. So the API number on page 2, let me find it. For the description of the depth severance, this Oxy Bulldog State number 1 is described, listed here. The API number is not complete, however. The API number should be 30015-29234. Same errors in the landman statement and application, but if we could get it corrected in this checklist, that would be good.
Sure, I can confer with the landman and get that fixed.
And with that, I have no further questions, but would like to continue this case so I could review those amended exhibits.
Thank you, Mr. Fordyce. So, Ms. McLean, the 28th of July?
That would be great.
Okay. All right, 28th
Thank you.
July. Yes. All right, we're off the record in that case. Let's move on to case number 6 on our docket, 26205, VF Petroleum.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Aberdeen Shield, appearing on behalf of VF Petroleum Incorporated, and I believe there's nobody that has appeared in this case.
Thank you. Go right ahead.
In this case, VF Petroleum seeks to amend order number R23924 to request a one-year extension of the well commencement deadline for the pooled unit in the Bone Spring Formation underlying Sections 35, 36, 34, and Township 19 South, Range 27 East, Eddy County, New Mexico. The pooling order, a copy of which is provided in the reference section of the hearing packet, allows for a one-year extension, particularly if it's the first request for an extension, which this is. In Exhibit A of the hearing packet, landman Mr. Jordan is VF's expert witness. He has testified previously before the division as an expert in land matters, and his credentials have been accepted of record. In his statement, Mr. Shaw testifies that VF Petroleum is in good standing under the statewide rules and the existing pooling order and has been working toward development of the unit. However, VF has experienced some circumstances that has caused delay. As a result, VF Petroleum respectfully requests the opportunity to move forward without interruption under a one-year extension, extending the drilling commencement date to August 13th, 2027. Exhibit B in the hearing packet shows that notice for this hearing was timely. The notice letters were timely mailed on June 16th, 2026, and the working interest owners, subject to the pooling order, were relocatable. A newspaper publication in the Carlsbad Current Argus was timely published on June 17th, 2026, to account for any unlocatable parties or any contingencies regarding notice. There have been no objections to VF's request or application. Mr. Hearing Examiner, at this time, I request that Exhibits A and B and all sub-exhibits for this case be admitted into the record and the case be taken under advisement. The witness and counsel are available to address any questions. Thank you.
Thank you. Your exhibits are admitted without exception. I'm curious, since there were no objections, why did this case go through the hearing bureau instead of the administrative process?
In the previous one, we did go through the administrative process, but it turned out that we got really close to the deadline, and since there's no safe harbor, we felt like that we were close enough to the deadline. We wanted to go ahead and do the hearing.
Okay. All right. And then your landman is on. Could you get him on the screen?
He is. Mr. Shaw?
Yes, sir.
Can you make your screen available, please?
Good morning, Mr. Shaw. I recognize you. Would you raise your right hand? Do you swear or affirm under penalty of perjury the testimony you're about to give is truth, whole truth, nothing but truth?
Yes, sir.
Thank you. Would you lower your hand and spell your name?
Yes, it's Jordan space SHAW.
Would you explain what these, I thought the term was circumstances, but there was a word before circumstances, which I didn't catch in his good cause.
Oh, I think I said some circumstances.
Some circumstances. Would you, Mr. Shaw, what are the some circumstances that require an extension?
Yes, sir. So when VF Petroleum was initially going to go about development on this property, oil had dropped to $54 a barrel approximately at that juncture. And we had difficulty, companies were letting go of rigs and had let go of rigs. And we had difficulty finding a hot rig in order to develop this prospect, which is 15,000 foot approximate lateral foot wells, which is the largest wells BF Petroleum ever drilled. We did end up finding a rig, but the rig slot that we were able to find was only large enough for us to drill the Angel Ranch 3634 FedCom 231H and the Angel Ranch 3634 FedCom 232H, and we had to let the rig go back to the other owner. Today we are actually spudding the Angel Ranch 3634 FedCom 233H with a sputter rig, and that rig is immediately moving over to the Angel Ranch 3634 FedCom 234H, and we will continue development in time to hit all the initial wells under this order.
Okay, thank you, Mrs. Shaw. That sounds perfectly reasonable to me. This case is taken under advisement. Thank you.
Thank you.
All right, let's move on to Muirborn Oil. It looks like we have two cases tied together. This is 26219 and 20. Entries, please.
Mr. Examiner Dana Hardy on behalf of Mewburn.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Frontline Royalty Partners and Frontline Royalty Partners F3, and we're only monitoring the cases.
Thank you.
Good morning, Mr. Hearing Examiner Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of Matador Production. Only monitoring these cases, no objection. I believe we're only in case number 26219.
Yes, that's correct. Thank you. Appreciate it. Ms. Hardy.
Thank you. In these cases, Mewburn seeks to pool uncommitted interest in the Bone Spring and Wolf Camp formations in sections 23 and 24, Township 22 South, Range 26 East in Eddy County, and will dedicate the units to the El Deuterino FedCom wells. Our exhibits include the testimony and land exhibits of Brad Dunn, who's previously testified before the division, and the geology testimony and exhibits of Tyler Hill, who has also previously testified before the division. Our notice, testimony, and exhibits show that notice was timely sent in June, on June 10th of 2026, and we did timely publish on June 17th, 2026. So with that, I ask that the exhibits be admitted and that the cases be taken under advisement.
Thank you. The exhibits are admitted in both cases. I believe we can take 26219 under advisement. I think there are some questions in 26220. Mr. Fordyce, that's correct?
Yes, Mr. Hearing Examiner, I have a question for the geologist in 26220.
All right.
Thank you. And I believe that Mr. Charlie Crosby is covering the geology today for Tyler Hill, who was unavailable.
And
so I
Mr.
believe
Crosby
Mr.
has been
Crosby is.
recognized as an expert for
He
this
has.
division? Thank you.
Yes.
Okay, good morning, Mr. Crosby. Raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, sir.
All right, thank you. Spell your name for the record.
Charles, Charles, Crosby, Crosby.
Thank you. And you've been recognized by this division as an expert in geology?
Yes, sir.
Thank you. Mr. Fordyce?
Good morning, Mr. Crosby. Looking at Exhibit B3, which is the cross-section on page 43.
Yes, sir.
Mr. Hill's statement says that the proposed landing zone has been labeled on this cross-section. But
yes, sir.
I'm having trouble finding it. I'm not seeing it.
Yes, sir. I noticed that myself reviewing these. We could fix that easily to draw in some arrows similar to what he did on the other case.
Oh, very good. I have no further questions. If we can have that amended exhibit by close of business today, that would be great.
We can do that. Thank you.
Yes, sir.
All right, thank you. We're all correct in that case. Okay, let's move on to Permian Resources 26221.
Jackie McLean on behalf of Permian Resources.
Thank you.
Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of Matador Production with no objections, just observing and preserving rights. Thank you.
Go ahead, Ms. Clay.
Thank you. In this case, Permian Resources is seeking to pool all uncommitted interest in the Wolfcamp Formation, underlying a 640-acre, more or less standard horizontal spacing unit comprised of the west half of sections 20 and 29, Township 23 South, Range 26 East in Eddy County, and will dedicate this unit to the asteroid wells. Exhibits were timely submitted and include geology testimony and exhibits of Matt Gray, and geology testimony exhibits from Cal Ward. Neither of them have testified before the division, so if there are questions, we'd ask that they be admitted as experts in their respective fields. We've also included notice testimony along with copies of the notice letter, which was timely sent on June 4th, and an affidavit of publication for June 10th. With that, I ask that the exhibits be admitted for case number 26221 and that the case be taken under advisement.
Exhibits are admitted. Mr. Fordyce, who do you have questions for?
I have questions for the landman.
Thank you. Is that Mr. Gray or Mr. Ward?
Mr. Gray.
Mr. Gray. Mr. Gray, would you raise your right hand, please? You swear or affirm under penalty of perjury that the testimony you're about to give is truth, the whole truth, nothing but truth?
I do.
Thank you. You can lower your hand and spell your name.
Matthew Gray, Matthew-Gray.
Thank you. And did you have a resume you can put up on the screen?
I do.
Thank you. It's some free advertisement, Mr. Gray.
It's exhibit A1.
Thank you. Would you go down, please?
Yes.
That's perfect. Thank you. Okay, thank you, Mr. Gray. You are considered an expert in petroleum land matters by this division. Mr. Fordyce?
Mr. Gray, I'm looking at exhibits A4 on page 18 is where that starts.
Okay.
Hold on 1 second. And my little Teams thing was covering my page numbers. Okay, here's exhibit A4.
Just specifically in section 29, this is showing tract 3B is 160 acres and tract 4B is 120 acres. If we scroll down to the next page, it says tract 3B is not 160, but 120, and 4B is 160, not 120. It just looks like these two might have, the two descriptions for those two tracks may have been switched and need to be corrected.
Yes, sir.
I have no further questions for Mr. Gray. If we could have that correction done by the close of business, that'd be great.
Yes, we can do that.
Okay, thank you. Thank you, Mr. Gray. And Mr. Fordyce, Ms. McLean said she would have that in.
Okay, great. Thank you.
All right, we're off the record in Permian Resources case. Let's move on to COG operating 26226.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of COG Operating, and there are no other parties.
Go right ahead.
Thank you. In this case, COG seeks to pool uncommitted interest in the Wolfcamp B interval of the Wolfcamp Formation, underlying a 1,600-acre non-standard overlapping horizontal spacing unit comprised of the south half of Section 29 and all of Section 32, Township 25 South, Range 35 East, and all of Section 5, Township 26 South, Range 35 East in Lee County. The unit will be dedicated to the Boater Federal Comm Wells. Exhibits were submitted timely and include the land testimony and exhibits of Caroline Frederick, who has previously testified before the division as an expert in petroleum land matters. We've also provided the geology testimony and exhibits of Preston Dupree, who has also previously testified before the division and has been recognized as an expert in petroleum geology matters. We have provided our notice testimony, which shows that notice was timely sent on June 17th, 2026, and we did timely publish on June 23rd of 2026. And with that, I ask that the exhibits be admitted and that the case be taken under advisement.
Exhibits are admitted without exception. Mr. Fordyce, who do you have questions for?
I have questions for the landman, Mr. Hearing Examiner.
Ms. Frederick, can you please turn on your camera?
I recognize Ms. Frederick. Good morning, Ms. Frederick. Would you please raise your right hand? Do you swear or affirm on the penalty of perjury the testimony you're about to give is the truth, the whole truth, nothing but the truth? Would you spell your name?
Caroline Frederick, CarolinFrederick.
Thank you. And I know that you've been examined as an expert in land matters. Mr. Fordyce, go ahead.
Good morning, Ms. Frederick. I'm looking at your statement. Should be on page 4 of the exhibits. And I'm looking at paragraph 4. There we go. It says that COG seeks to pool all uncommitted interest in the Wolfcamp B interval. If we could move to page 6 in paragraph 10. Paragraph 10 says, due to the depth severance, the applicant seeks to pool uncommitted interest from a stratigraphic equivalent of 12,736 feet TVD in such and such log to the base of the Wolfcamp formation. It sounds to me like those two descriptions for the vertical extent are different. Would you agree?
I'm sorry, could you repeat the question?
It sounds like the description in paragraph 4 for the vertical extent for pooling and the description in paragraph 10 for the vertical extent for pooling don't agree, are two different descriptions for the vertical extent. Would you agree?
So for paragraph 10, the depth provided is meant to mark the top of the Wolfcamp B and then define that Wolfcamp B. Could we go back to paragraph 4? If we need to add a depth in paragraph 4, good.
Well, I think in paragraph 10, if you're pooling from the depth severance to the base of the Wolfcamp, that seems to include more than just the Wolfcamp B. Would you agree? So I'm just trying to narrow down which one is it that we, what's the correct description so we can include that in the compulsory pooling application checklist.
Yes, so we're trying to pull the Wolfcamp B interval, and the depth that I was provided by our geologist was that the top of the Wolfcamp B is that depth that's in paragraph 10. So we're just trying to clarify like the exact interval that we're calling the Wolfcamp B, if that makes sense. But I think our geologist might be able to speak more to the depth situation, if that makes sense.
Okay. So let me try to rephrase the question. In the compulsory pooling application checklist, it just says that applicant is seeking to pool this vertical extent Wolfcamp B, but it also, again, in your statement on paragraph 10, it says to the base of the Wolfcamp. So that would include more than the Wolfcamp B. I'm trying to ascertain what is the correct vertical extent for pooling on the compulsory pooling application checklist that we need to include here.
Gotcha. I'm not sure what the base of the wolf camp is, but if we need to include that, I think we can. But yeah, our just pool.
Do we need to consult with Mr. Dupree?
Probably that might be. He's out for a family matter, but we have Ben Brayman ready to fill in for him.
Ms. Hardy, do you understand the question that I'm asking?
I do, and I think that it's been my understanding that the interval that's identified is the Wolfcamp B. But I think our geologist, Ben Brayman, who's covering for Preston Dupree, is available to answer that question if that would be helpful.
Yeah, I just want to make sure that you've listed the correct vertical extent in the CPAC, whether it's just the Wolfcamp B or you're pulling from the depth severance down to the base. I'm pretty sure that would be two different things because there's portions of the Wolfcamp below the B, if that makes sense. So if we can just make sure that, how do we go about making sure we got the right vertical extent on the CPAC, I guess?
If you want, I think I can answer a little bit of that.
Sir, you're not sworn in. Okay. Mr. Fordyce, do you want to ask this gentleman a question?
Mr. Hearing Examiner, if he could shed some light on clearing up this vertical extent, and then that would be great.
And who is this gentleman?
This is Ben Brayman, who is our geologist. He's previously testified as an expert before the division.
Okay. All right. Do we still need to share the screen?
Probably not.
Okay.
I can.
If we do, it's fine. I just would like to see. There we go.
There we go.
Mr. Brayman, raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
Thank you. Would you lower your hand and spell your name?
Is B-E-N, last name B-R-E-Y-M-A-N.
And Ms. Hardy has told me that you've been previously qualified as an expert before this division. In what field is that?
That's petroleum geology.
All right, thank you. Mr. Fordyce?
Mr. Brayman, I guess I'll ask the question again. So there's a discrepancy whether COG seeks to pool only the Wolfcamp B or COG is seeking to pool from the depth severance to the base of the Wolfcamp, which would include more than the Wolfcamp B. I just want to make sure that we have it listed correctly in the compulsory pooling application checklist, which right now says Wolfcamp B. Do you understand what I'm asking?
Yes, sir. And I believe part of it is referencing the Tele Deluxe 32 state 4H pilot hole. And in that specific pilot hole, we don't have depths into the Wolfcamp C. And so what we could provide is, a Wolfcamp C depth to have that the base of the Wolfcamp B.
Again, the CPAC just says that COG seeks to pool just the Wolfcamp B, and COG would be fine with that statement and showing that on the CPAC in the exhibits and in the order.
Sorry, I couldn't hear the first part of your question. Can you repeat?
Sorry, I'll repeat. So right now, the compulsory pooling application checklist, which becomes part of the order, says that the pooling vertical extent is just the Wolfcamp B. If COG is good with that statement, then I think we can move on.
Yes, I believe so.
I believe so. Mr. Brayman, is that a yes or a no?
Sorry. Yes, we could do that.
Mr. Fordyce?
Okay. Then no further questions, so we can take this case under advisement.
All right, perfect. Thank you. All right, we're off the record in this case.
Thank you.
Let's move on to several Chevron USA cases, but I'm going to split the first one off and call it by itself. 26227.
Good morning, Mr. Examiner. Dina Bennett on behalf of Chevron USA Inc., and there are no other parties that have entered an appearance in this case. Thank you. So in this case, Chevron is seeking an order pooling uncommitted mineral interest owners in a 320-acre spacing unit, and I'll save the division's ears from describing the spacing unit. It's a Bone Spring spacing unit. It covers 2 pools. And in this case, we've submitted the usual suite of exhibits, the land testimony from Mr. Nick Angel, who's previously testified before the division, and his credentials have been accepted as a matter of record. The geology testimony of Colin McRitchie, who has not previously testified before the division, so if there's questions for him, he'll need to be qualified. And then my self-affirmed declaration showing that notice was timely mailed and that publication was done timely. And one thing, 2 things I just wanted to point out about this case, and I'll say the same thing about the next case when we call it, but in these cases, Chevron is seeking to apply for non-standard locations administratively, and also in 26227, there's an overlapping spacing unit, and Chevron itself provided the notice for the overlapping spacing unit request, and I included in the materials a statement in Mr. Angel's declaration testifying to the fact that he had provided the notice, and I also provided an exhibit A10 that shows the parties to whom notice of the overlapping spacing unit was provided and when. So with that, I would ask that the exhibits in case number 26227 be admitted into the record and that the case be taken under advisement.
Admitted without exception and taken under advisement. Now I'm going to call the other 3 cases separately. 26228, 26241, 26242.
Thank you, Mr. Hearing Examiner. Would it be possible to do 26228 separately, just because it might be a little easier to do these in bite-sized chunks?
By all means, you can present 26228, but would you enter an appearance on all 3?
Yes, I will. This is Dina Bennett on behalf of Chevron USA Inc., and no other parties have entered an appearance.
Okay, why don't you present 26228 by itself then?
Thank you. So this is a companion case to case number 26227. And in this case, as in the prior case, Chevron is seeking to pool uncommitted working interest owners in the Wolf Camp formation in the same 320-acre spacing unit. In this case as well, we timely submitted exhibits, including exhibits by Mr. McRitchie, who has not previously testified before the division. In this case, again, Chevron is seeking NSL approval administratively to the extent necessary. But in this case, there wasn't an overlapping spacing unit, so I didn't include any information about overlapping spacing units. And so with that, I would ask that the exhibits in case number 26227 be admitted into the record and the case be taken under advisement.
Admitted without exception. Mr. Fordyce, who do you have questions for?
First, I have a correction to the pool codes here, actually.
Okay.
In doing the research on our pool maps, for this Wolf Camp spacing unit, the Antelope Ridge Wolf Camp Pool 2220 actually extends north into the south half of Section 21, which Chevron has identified as a different pool with pool code 98242. What we need to have done is correct the CPAC and the C102s to reflect that this entire HSU is actually in that Antelope Ridge Wolf Camp pool code 2220 pool. There is one error also in the land exhibits. I don't know that we need to call the landmen. It's just that there's AFEs provided for I believe the 401 and 402. This case deals with a 601H. So we just need to include the correct AFE for this 601H well. And I have no further corrections.
So, Mr. Fordyce, you don't have any questions for any of the witnesses?
No, I just have those corrections to the pool code, and if the landman could provide the correct AFE to be included in the amended exhibits, that's what this case needs, Mr. Hearing Examiner.
Thank you, Mr. Fordyce. Ms. Bennett by 5 p.m.?
Yes.
Thank you.
Thank you.
Leave the record open then.
Thank you
All
very
right,
much.
let's go to well, you were going to present 41 and 42 separately.
Yes, thank you. So these two cases are companion cases with the other cases I just presented. However, the twist or the hook in these two cases is that there is a J hook well. So there's a well that is shaped sort of like a fish hook. And so that's why I wanted to present these two cases separately. So in these two cases, Chevron is seeking to pool uncommitted mineral interests in what would be the east half of the units. These are 480-acre units. And originally when I filed these applications, let me finish my intro. We submitted the usual suite of exhibits, including the declaration of Mr. Nick Angel, who's previously testified, declaration of Colin McRitchie, who has not previously testified, and the usual suite of exhibits, as well as the notice exhibit showing that notice was timely mailed and published. So when we first applied for these J-hook wells, I thought that there needed to be a non-standard unit approval to correspond with these wells. But upon further reflection and review, I believe that a non-standard unit approval is no longer necessary. And if the division agrees with me, then we would dismiss that portion of the application from the application. If the division believes that a non-standard unit approval is required, I did include notice information demonstrating that we did supply notice to the offsetting tracts as required under the division's rules. And in this case, again, there are some non-standard locations which we do have to apply for administratively. And in the Bone Spring case, which is case number 26241, Chevron sent the overlapping notice information itself, and I included that in Mr. Angel's written declaration, as well as an exhibit showing when the notice was mailed and that it was done timely. So with that, I would ask that the exhibits in case numbers 26241 and 26242 be admitted into the record, and that the cases be taken under advisement. And I appreciate any assistance that the division can provide in terms of the non-standard unit. Thank you.
Exhibits submitted without exception. Mr. Fordyce, who do you have questions for?
I don't have a question per se in this case, but I would like to address Ms. Bennett's question about the non-standard unit. The division has reviewed this proposed spacing unit, and it is appropriate to request a non-standard unit because it's built with 40-acre, continuous 40-acre building blocks, but then has a 160-acre block adjacent to it, and therefore the NSP is appropriate, which you've requested and done notice for.
Thank you.
So I don't have any questions for 26241.
And 42?
242, the same applies with regard to the NSP, and also the same corrections to the pool codes, as this is a wolf camp. And so the same applies here as for the previous wolf camp case. So the entire spacing unit will end up being in the Antelope Ridge Wolf Camp 2220 pool, which again extends into the south half of section 21. So for 26242, we will need corrections to the CPAC and the C102s for the pool code.
Ms. Bennett, 5 p.m.?
Yes, thank you very much.
All right. So both cases will be taken under advisement. once you submit the proper documents. Thank you.
Thank you.
All right, let's move on to Mewbourne Oil. It looks like we have two cases here, 26230, 26231.
Hey, Mr. Examiner, Dana Hardy on behalf of Mewbourne, and also case 26232, which is listed number 17.
And 26232.
I could present these together.
Go right ahead.
Okay, thank you. And no other parties have entered an appearance.
I see, thank you.
These cases involve 2 Bone Spring spacing units and 1 Wolf Camp spacing unit. Those units will be dedicated to the Buffalo Thunder 9/11 FedCom wells. Our exhibits include the land testimony and exhibits of Josh Anderson, who has previously testified as an expert in petroleum land matters. We have provided the geology testimony and exhibits of Charlie Crosby, who's previously testified as an expert in geology matters before the division. Our notice, testimony, and exhibits show that notice was timely sent on June 16th, 2026, and we did timely publish on June 24th, 2026. So with that, unless there are questions, I ask that the exhibits be admitted and that these cases be taken under advisement.
Your exhibits are admitted in all 3 cases without exception. I believe Mr. Fordyce has questions about the C-102s.
That's correct, Mr. Hearing Examiner. Perhaps I could question the landman about the C-102s.
Perfect. Would that be Mr. Crosby or?
Mr. Anderson.
Anderson.
Please.
I see you, Mr. Anderson. Okay, would you raise your right hand, please? Do you swear or affirm under the penalty of perjury that testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you. Would you spell your name, please?
Josh Anderson, JOSHANDERSON.
Okay. And you've previously been qualified as an expert in petroleum land matters before this division?
Yes, sir.
All right, Mr. Fordyce?
Yes, I'm looking at, actually, I pulled up 26230, but the C-102 on page 11, we can start there, I think.
Okay.
So, Mr. Anderson, I did a land search for sections 9, 10, and 11. All 3 sections are regular sections throughout, so built by 40-acre units. So I'm looking specifically, let's look at the first take point for this 521H well. It says the first take point would be 2,718 feet FEL. Given that these are regular sections, there's only 2,640 feet available from the east line to the center line. So 2718 is not unit B anymore. That would be unit C and should be measured from the west line, if you follow
Yes,
that
sir.
logic.
Yeah, I
Same
do.
for the surface location. 2745 is not unit G anymore. That would be unit F and should be measured from the west line. You see what I'm saying here?
I do. And we discussed this before we submitted these exhibits with our engineers, and we had these sections surveyed, and these were the actual surveys and how they came back, and they are not technically regular sections, was the way it was described to me. Usually it would be, and I understand your footages, but when the surveyors were out actual on location, this is what it came back as. So I don't really know how else to explain that.
I think that's the case for the other wells, the 523H and the 4 wells in the Purple Sage Wolfcamp case. So I guess if I hear you correctly, even though my land search said these are regular sections, this is what your surveyor come up with, and this is accurate to the best of your knowledge and his knowledge.
Yes, sir. Yeah. They seem to be regular sections, but upon actual surveys, they are not.
Okay, well, I guess that answers my question regarding the C-102s. seems a bit unusual, but I'll believe your surveyor, I guess. Mr. Hearing Examiner, I only have a question for Mr. Crosby. One last question for Mr. Crosby, the geologist in 26232, the Wolfcamp cases.
Okay.
Case.
Yes, sir.
Okay. I remind you, you're still under oath.
Yes, sir.
Go right ahead, Mr. Fordyce.
Mr. Crosby, I'm looking at your cross-section on page 40, Exhibit B3. You're showing a lower target here for Buffalo Thunder 911, FedCom 821H and 823H, and what appears to be what you're calling a Wolfcamp D. Just wanted to ask and verify, is what you're showing on this cross-section as Wolfcamp D, is that equivalent to the Cisco or Canyon formations in the Pennsylvania system?
It is not.
Thank you, Mr. Crosby. I just wanted to get that on the record, and I have no further questions for these three cases.
Do the C102s need to be corrected, or are they fine the way they are?
According to their surveyor, apparently that's correct, although it seems odd, but we'll go with what their surveyor said, I guess.
All right, perfect. Okay, we're off the record in these cases, and they're taken under advisement.
Thank you.
We now move to Burnett Oil, 26245.
Good morning, everyone. Ben Holiday on behalf of the applicant, Burnett Oil Company.
Good morning.
So I have a similar situation to Mr. Savage's earlier in this case number 26245. Burnett's seeking to extend the time to drill under order number R23930, which was issued on September 8, 2025. It was amended a few months later by R23930-A on November 26th. This is one of those orders where the paragraph 21 departs from the prior protocol requiring good cause showing and provides that the extension will be granted if notice is provided, application is made, notice provided, and no objection has occurred. So we noticed everyone on June 16th, 2026, that 20-day period ran after the date exhibits were due. So just out of an abundance of caution, I filed the exhibits. But once that 20-day period had run, we filed our order compliance report. And I think our preference would be to take this through the administrative route.
So would you like to dismiss this case?
Yes.
Okay. Then just file a notice of dismissal and I'll sign the order. Thank you.
All right. Thank you, guys.
All right. Thank you, Mr. Holliday. We're off the record in that case. And that completes Mr. Fordyce's contribution to today's docket. Thank you, Mr. Fordyce. Let's now turn to a group of cases in which we have a different technical examiner. Do we have you with us?
Yes, Patricio Sanchez.
There you are, Mr. Sanchez. Welcome. Okay, let's start out with Coterra Energy, number 19 on the docket, 26249.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy in case 26249 and 26250.
Yes, and 26250. Thank
and there are no other parties that have entered an appearance in these cases.
Perfect. Go right ahead.
Thank you. In these two cases, Coterra Energy Operating is seeking an order pooling uncommitted mineral interest owners in a 640-acre spacing unit. And in both of the cases, Coterra is seeking, well, I'll get to that in a moment. We timely filed exhibits, including the self-affirmed declaration of Tyler Van Horn. Mr. Van Horn has not previously testified before the division, so if there are questions for him, he'll need to be qualified.
He's an expert in what?
Land.
Land, thank you.
And then we also included the self-affirmed declaration of Stacy Fry, who has been previously qualified. Unfortunately, she wasn't able to be here today, so Josh Day is filling in for her if there are any geology questions. And while he's presented cases or been involved in affidavit cases before, his credentials have never been evaluated by the division.
Okay.
And then we also And we included the usual suite of exhibits for both of those witnesses. And then I also included my notice, which shows that notice was timely mailed and timely published. And just a bit of clarification for the case number 26249, which is the Bone Spring case. In both cases, I inadvertently didn't do the non-standard unit notice on time. And so that is something that we're going to need to cure and come back for. But it really only impacts case number 26249 because in case number 26250, the Wolf Camp case, it's a U-turn well, and the way the well is situated, in my opinion, after reviewing the materials, it doesn't appear to need a non-standard unit approval because of the fact that the well is on the quarter-quarter section lines in both the east half and the west half of the unit. And so I'm definitely looking forward to some advice from the division on that or feedback from the division, but it could be that case number 26250 does not need any additional notice. So with those two explanations, I would ask that these cases that the exhibits be admitted into the record and the cases be taken under advisement.
The exhibits are admitted without exception, and I believe 26250 can be taken under advisement at this time. Is that right, Mr. Sanchez?
Yes.
Okay. We do have questions, 26249. Mr. Sanchez, who do you have questions for?
It would be for the geologist.
Geologist. That's Ms. Frey, who's not here, but who's standing in for?
Mr. Day.
Day, Mr. Day. Okay, there we have Mr. Day. Mr. Day, please raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Spell your name, please.
Joshday.
Thank you. And you're seeking to be recognized as an expert in what field?
Petroleum geology.
Would you have a resume to look at?
I'm working on getting a resume. I didn't submit it with this packet, but I have it in a prior exhibit packet,
fine.
so I'm working on getting that.
I can just do it by questioning Mr. Day if that's easier.
That might be easier. We did prepare him for questioning at the last hearing, so he's ready to go.
Fine. Mr. Day, would you give us some background in your education that applies to this field of expertise?
Yes, sir. From an education standpoint, I got a Bachelor of Geology from East Tennessee State University in 2013. Then did my master's in geology at Colorado School of Mines, graduating 2015, and been working as a petroleum geologist since then.
Okay, and what companies have you worked for, and what was your title at those companies?
Worked, first of all, at ConocoPhillips from 2015 to 2021 as geologist and senior geologist, working almost exclusively in the Permian Basin, both Midland and Delaware Central Basin platform as well. Did geosteering, did business development geology, did some asset geology, a lot of mapping, dealing with reservoir characterization in those different areas, different formations. After that, went to Edge Systems, which is a geological services company. I worked as their director of geoscience there, directing a program that did a lot of gas analysis, isotope analysis, and then also ran their geosteering program. And then since last year, joined Coterra, now Devon, and have been working as a senior geologist with them in their Delaware Basin assets since then.
All right, thank you, sir. You're so qualified. Okay, Mr. Sanchez, go ahead.
Yes, could we go to page 69 and page 70 of the exhibits? That would be the B section for the geologic information. And starting basically with, it'll be basically point 11 through 13. These wells are located on top of the Capitan Reef, and it's in the 4-string casing area. And, this language regarding the geologic risks doesn't address the sequencing of drilling these wells because they're drilled off of the same pad. And I'm just wondering if there's if that's something that needs to be addressed in these wells, when we have these U-turn wells and they're all coming off of the same pad, if there isn't actually a preferred sequence that these wells need to be drilled in order to minimize geologic risk. I'm just throwing that out there rhetorically because it just seems like it could be an item of concern.
And the question, sorry, what's the specific question there, sir?
What order of sequence will these wells be drilled in?
I would have to check, and a lot of times that is a little bit in flux, just depending on certain operational parameters. But is there an extra geologic risk if you do these in a different direction or a different order because of the reef? By the time we get to the actual U-turn portion and the production lateral, the rest of that uphole section is already behind casing and cement. So I don't believe that there would be any additional risk because of that or due to sequencing.
Okay, and then when you get into your landing point discussion, there's no geomechanical risks in the placement. In other words, there's no hierarchy in how you place those wells. There's no comminution between the laterals at that point where you could have severe loss circulation or sloughing, because these wells do turn, and I don't know that you've had any issues with key seats in those turns, but I'm just wondering if geomechanically, if that might be something that's a concern.
Not due to sequencing, the different orders between the wells. If there is a geomechanical risk, I don't believe that doing one bench before a different bench is going to make a particular difference there, other than to inform and have some learnings from previous wells that you could perhaps be prepared for on subsequent wells. But that would be the only real way that the sequencing would inform your risk profile.
Okay, and if you do have those kind of learnings, you'll start in future applications like that, like these,
yes,
including that?
Yes, sir.
Okay, well, that answers my question on that, so I don't have anything else for the geologist.
Is there anything else you need for this case?
No.
Okay, so then can his case be taken under advisement?
I think on the NSP issue, yeah. I personally thought that everything was in order in the application myself, so.
Mr. Hearing Examiner, I did not, I mean, in full disclosure, I did not do the NSP notice for the Bone Spring case, which is the one we're talking about right now, 26249. So I would ask that that case be continued to August 6th to allow me time to cure the notice.
Perfect, August 6th.
Okay.
All right.
Yeah,
So, Mr. Sanchez, this case will come back around. You may not need to be present for it. You may just sign off on it after you review the notice, but it has to come back around.
Okay, that's fine.
And I apologize to Mr. Sanchez. I could have made that more clear in the materials, and so I apologize that it wasn't clear that I hadn't done the notice for that. And in the future, if I realize that before I file the exhibit packet, I will try to do a better job of noting that.
Thank you, Ms. Bennett. All right, we're off the record in that case. We're going to go on to Devon Energy Production 26251.
That's been dismissed.
It has?
Yes, we filed a notice of dismissal yesterday.
You did? Thank you. Dismissed. Is it going to come back around?
No, they've reached an agreement with all parties, so we are
wonderful.
good to go on this one.
Excellent, thank you. Okay, I know the next two on the original docket were dismissed by, I think you, Mr. Rankin, the Mewbourne oil cases.
I'm sorry, I'm not seeing which ones you're
Well, because the latest worksheet, we removed the two cases, but on my version, we had Mewbourne oil, the Runaway 2630 wells.
I think those were placeholders for extensions.
That's it. That's it.
Yeah, and so we're working through the process.
Yes, yes, of course, we all are. All right, moving on to Avant Operating 26253.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2 LLC, and there are no other parties in the case.
Go right ahead, Ms. Bennett.
Thank you. In this case, Avant Operating 2 seeks an order pooling all uncommitted mineral interest owners in a 640-acre non-standard spacing unit in the Upper Penn South Pool. And we timely filed exhibits, including the self-affirmed declaration of Tiffany Sarantinos, who's previously testified and been qualified, the self-affirmed declaration of the geologist Josh Payne, who's also previously testified and been qualified, and my notice information showing that notice was timely mailed and publication was done timely. And just a few comments on the exhibits before I turn it over for questions. In this case, I did not realize when I filed the application that Section 6 is an irregular section. And so in going back through the materials preparing for for filing exhibits, I realized that, and I updated the compulsory pooling checklist to reflect lots and the irregularity of the Section 6, and I updated Ms. Sarantino's declaration to also reflect that that Section 6 is irregular. And then the building blocks for the shoe bar pen code on the division's website says it's 80-acre building blocks, and the division, when it enacted the horizontal well rule, said, and I'm paraphrasing here, that any of those old building blocks are superseded by the rule unless it's the Purple Sage Wolf Camp order. But that hasn't always proven to be true, that in some circumstances those old building blocks are still relevant. So I noted that whether these are 80-acre building blocks, which is what the pool code says, or 40-acre building blocks, it's still a non-standard unit. And we did do the non-standard unit notice. And the other thing I did was I accidentally transposed the well names, the well numbers in the application, but that's been corrected in the materials. So it was just a matter of me putting the 831 with the 832 description and vice versa. So I think that those are all the notes I had to take or had to pass along to the division. So if you have any questions, I'm happy to answer them, but I'd also ask that the exhibits in case number 26253 be admitted into the record and the case taken under advisement.
Admitted without exception. Mr. Sanchez, do you have questions or just directions in this case?
Just a small additional correction.
Okay.
Under page 36 of 57, just exhibit A9. The little yellow box there says spicy chicken.
Oh. Yep, that is a relic from
Chicken on the
Spicy
brain.
Chicken. Yep, I see that, page 36 of 57. So just change the name of the unit.
Yes.
Yeah,
Okay.
that little yellow box there.
Okay.
And
so you can do that by 5 o'clock?
Yes, I can.
Okay, very good. We'll take this case under advisement at that time.
Thank you very much.
All right, thank you, Ms. Bennett. Let's move on to Catamount Energy Partners, 26257.
Good morning, Mr. Hearing Examiner Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of the applicant in this case, Catamount.
Thank you.
I don't believe there are any parties that have appeared in this case. Catamount seeks to amend Order R, Compulsory Pooling Order R 23613, to extend the drilling deadline by 1 year and to add an additional well to the authorized wells under this compulsory pooling order. The order originally provided for 3 initial wells, so Catamount is now seeking to drill 4 initial wells. This will be the second extension of time requested in this case. And as our witness, Ms. Greer, testifies in her statement, there's good cause for this extension due to efforts, delays trying to get access to water from the Navajo Reservoir. It's a process to do, and they're working on it. They are, as I understand, close, working on getting a permitting location for a physical pump on the shore of the lake and a right-of-way from the United States Bureau of Reclamation in order to have a pipe to transport the water. Neither has been approved yet. Once approved, there will also be timing restrictions during which Catamount will not be able to use the pump between December 1st through March 30th. And so for that reason, there's a lot of restrictions on when and how they can use the water, even once they get it. So with that, Mr. Hearing Officer, we ask that the case and the exhibits be accepted into the record and the case be taken under advisement unless there are any questions. The exhibit packet does include notification, proof of notification. All parties were notified timely, and an affidavit of publication was provided also timely in a newspaper in the county where the location is located.
The exhibits are admitted without exception. Mr. Sanchez, do you have questions for the geologist?
Yes, we have a new well that's added to this this package, and I couldn't find. Well, anyway, yeah, I do.
So I'm happy to address, I mean, I'll address this on a legal basis. Sure. And if we need a geologist, I'll bring it back. Okay. So Mr. Sanchez, this case was already presented for compulsory pooling. The geology was already admitted, and the formation was determined to be appropriate for compulsory pooling by horizontal wells. So because of that, it's already been deemed to be accepted for compulsory pooling. Practice has been that we do not need an additional statement from a geologist for that reason.
Mr. Sanchez?
Okay, well, if that's allowed, I mean, we're adding a new well, and there's, you know, changes in the wine rack and those sorts of things, but yeah, I wasn't aware of that. So.
Well, Mr. Sanchez, that's a legal argument. As a technical reviewer, are there any, is there any data or information that you need to make a determination on the good cause extension?
Well, I mean, if the geology is not, we don't have anything that's been added, you know, putting in this new well, I suppose we can use what's already been submitted, but yeah.
Okay. Mr. Rankin, it seems like there's no questions for your geologist.
Yeah, I mean, I'll just say that, you know, under the horizontal well rule, there's no spacing limitations, there's no density requirements and limits, so it's generally been left up to the operator to determine the best spacing and orientation of its wells unless there's an objection by a party. And so that's generally been the practice. And here we've established already that the spacing is appropriate for horizontal well development. There's no pinch outs, other impediments to development by horizontal drilling. So if there are specific questions or concerns, we're happy to try to address them. It's not that we didn't want to, it's just that the practice has been not to when we've already established the basis for horizontal development in the spacing unit.
Mr. Sanchez, anything further on this case?
No, that's fine. It would be helpful in the future, though, I think, to go ahead and include those geology exhibits when you have a different reviewer going over the project. Might be helpful to include that.
We'll leave that where it is.
Thank you.
So we'll take this case under advisement. Thank you, Mr. Rankin. Now we have a large group of Colgate cases. Ms. McLean has turned her microphone on. I'm going to read the numbers. 262, 54, 56, 58, 59, 60, 61, 63, 65, 66, 68, 70, 72. Entries, please.
Yes, Jackie McLean on behalf of Colgate. And there's no other parties that have entered an appearance. In these cases, we are seeking a second extension of the deadline to commence drilling, so we are not eligible for the administrative process, and that's why we are here on this. There are no new wells. The development plans remain the same. We have requested a second extension in these 12 cases so that Permian Resources can evaluate offset drilling results for the well spacing in this area. The wells that they are using to do that have begun producing, so they are underway with this process, the production data will be available soon, and they will be able to spud these wells within the next year. We have included the exhibits and land testimony of Matthew Gray, who has now been admitted to testify as an expert in petroleum land matters. And we've included notice testimony along with the notice letter from June 12th and an affidavit of publication from June 17th. And I ask that the exhibits be admitted for these cases and that the cases be taken under advisement.
The exhibits are admitted without exception. The cases are taken under advisement. Thank you.
Thank you.
Moving on to Chevron USA 26262 and 26271.
Hi.
Dina Bennett on behalf of Chevron USA, Inc. in case 26262 and 26271, and there are no other parties that have entered an appearance in these cases.
Please proceed.
Thank you. In these two cases, these two companion cases, Chevron is seeking to pool uncommitted interests in both a Wolf Camp and a Bone Spring pool. Underlying, well, it's a 639.92 acre spacing unit. And in the materials, we provided the usual suite of exhibits, which is the self-affirmed declaration of Nick Angel, who's previously testified and whose credentials have been accepted, and the self-affirmed declaration of Colin McRitchie, the geologist who's not previously testified, but he submitted the usual suite of exhibits. And then my self-affirmed declaration showing that notice was timely mailed and that publication was timely. And I did just have a couple of updates on these applications. In these cases, we are working on the non-standard unit location approvals to submit administratively. And in these cases, there's a party named Imperial that I inadvertently included as uncommitted in the committed uncommitted chart, and they really should be shown as committed. And in the meantime, as of yesterday, Chevron was able to get voluntary joinder from another party, Pride Energy, and another party was actually acquired by Imperial. So we do need to file amended exhibit packets in both cases to update the committed and uncommitted chart as of the events of yesterday.
It sounds like something you can do by 5 p.m.
Yes, definitely.
Okay.
And with that, I would ask that the exhibits in cases 26262 be admitted into the record, and case 26271 be admitted into the record, and the cases be taken under advisement.
Admitted without exception, and as long as you provide that correction to the committed, uncommitted list, they will be taken under advisement.
Thank you. Would it be possible to recall 2 of the Chevron Wolfcamp cases that we talked about earlier today?
Are those the 227, 228 cases? Or is that the 241, 242?
It is 26228 and 26242.
Ah, okay. Let me recall 26228, 26242.
Thank you. Mr. Fordyce was the technical examiner for these 2 cases, and he indicated that the Wolf Camp here, that the C102s and the CPAC needed to be included to reflect that the pool 2220 goes all the way up into section 21. And Chevron has, in the meantime, emailed me an email from the division from Mr. Gomez confirming that there are the 2 pool codes. And so we were just hoping to get some clarification, and I realized that Mr. Fordyce is not on.
I think he's back.
Okay.
I think he heard his name.
Okay. And I'm happy to share my screen to show that email. I'm just trying to find it right now again. I was trying to email it to you all when I lost focus. So, Mr. Fordyce, I'm not sure if that email would be helpful to you, or if what I can do to help this conversation. Of course, if it turns out that your original direction is correct, we're already working on revising the C102s to reflect the pool code 2220. But before we did that, we just wanted to make sure we were doing the right thing.
Yeah, I hear what you're saying, Ms. Bennett. To that, I guess I would say, I checked that pool map myself like 6 times, and then had some other folks look at it, and they said, yeah, I think that looks right to me. It goes up into section 21, the south half of it anyway. At the same time, Mr. Gomez, from time to time, might make changes to those pool maps and is an APD reviewer. So I would say if he says the pool is correct, as you had it listed, that might trump what I'm telling you.
And I'll just show you the email real fast.
Although I would say again, I checked it 6 times and had other people look at it, but these, these pools can be a little confusing.
Well, what we could also do, and I'm not trying to, punt, but I am, is we could submit also C102s that show just the 2220 pool code and an updated CPAC that shows both iterations of what we're talking about today, if that would help resolve the issue, at least for the moment. But yeah, here's the email from Mr. Gomez. And unfortunately, when I zoom in, it makes it so you can't read it, but it says the Wolf Camp south half of section 21, township 23 south, range 34 east is in, that particular pool is in, or south half of section 21 is in 98242, which is the pool code that we put for the south half of section 21. So I'm happy to do whatever the division thinks is the best path forward.
I noticed that the email, hold on, Mr. Fordyce. I noticed that the email is from April 15th. Could something have changed, Mr. Fordyce, in the interim?
That's possible. I have a suggestion that, let me see, for those two cases, the only question for those two cases was this question of the pool codes, aside from the fact that we needed in 26228 the proper AFE included for the 601H well. What I could do in the very short order probably is verify. And what was the date on Mr. Gomez's email?
April 15. April 15.
Let me, if you would, Ms. Bennett, if you'd allow me just a little bit of time to confirm whether it has changed or what is correct, and I can provide that information to you so that we get the right exhibits submitted by close of business today.
I'm willing to leave it open for until Monday if you need a little bit more time to figure this out, Mr. Fordyce. I'm not trying to rush you.
I think I can sort it very quickly, Mr. Hearing Examiner.
Okay. All right. So then, are you going to communicate with Ms. Bennett directly?
I will.
Okay. So I don't think we need to stay on the record for this.
No.
All right. Well, thank you for bringing that to our attention, Ms. Bennett.
Thank you.
And thank you, Mr. Fordyce and Mr. Sanchez.
Yes.
And
Thank you all.
Mr. McClure. Have a good day. We're off the record.
Thanks, everyone.